And now, panel, I would like to ask you all to consider some key takeaways for this event, some things you'd really like to leave the audience with. And I'd like to structure this so that we have your responses in the order that you spoke. So we would go from first Barry Furman to Ann Cherry Barnett, and then Roger James. So Barry, what are some key takeaways for this event?
If I could, I'd like to just spend a minute talking about key takeaways and then give a reality show example, a real example of what I have pending in court. I think the biggest takeaway is that there are dangers, there are risks to independent contractors, but there are ways to minimize those risks, and there are also mitigation provisions in the Internal Revenue Code, and I address those. But I think that what would be really helpful is to talk about a case that I have pending. I have a client who is headquartered in California. I am not in California. I'm not admitted in California. So I happen to have local counsel involved in this, and it happens to be the Ogletree firm. And this has an international client, so they probably have consulted with Roger. And I didn't know Ann at the time, or maybe Ann would have been my local counsel. But in any event, it's a case that it's a complaint for a refund in the Superior Court, and it involves the Employment Development Department, which is extremely, extremely aggressive, worse than aggressive. And they're manipulating an unemployment compensation claim that's supposed to be suspended. Instead, they let it loose, and they're pushing it, and they're using it as a stalking horse to gain discovery, pretrial discovery of their case that's pending in the Superior Court case. That'll be tried in February, and in fact, this is a case that the EDD has selected as a test case. It's very important to them, and it's going to be an important precedent. Thank you.
And thank you, Barry Furman. Ann Cherry Barnett, some key takeaway thoughts?
Yeah, like Barry said, you can do an independent contractor relationship successfully, and so to that end, I would suggest misclassification audits. Audit your current employee relationships, especially the ones that you already have that you've made independent contractors, to make sure that they comply with current law. Audits can be expensive, but they're far cheaper than litigation on a misclassification issue. And they can be done fairly efficiently. It's something that I do a lot for my clients. Also, I would encourage everybody to watch the Save Local Business Act that just passed through the House. It's anticipated to get some favorable treatment by the Senate to stay current on what the rules are going to be related to joint employer liability, to make sure that you are staying clear of that to the extent possible. And then the third point is, don't be afraid to make your independent contractor agreements clear and explicit, but most importantly, behave according to what you've put in that contract. I've seen some great independent contractor agreements, but unfortunately, the companies haven't adhered to the behavior that's outlined in there, and they've gotten dinged with a misclassification claim. So those are my 3 takeaways.
Thank you very much. And finally, Roger James, some key thoughts before we wrap up.
Thank you. Well, I've just got 2. Firstly, although the principles as to whether someone is an employee or an independent contractor are remarkably similar around the world, the consequences differ greatly, and employment laws for employees differ greatly. So my first key takeaway is take advice before going to any country on the laws of that country. At Ogletree, we give country reports to clients setting out those laws for whatever country it might be, but it's really important to understand those. And secondly, when it comes to using your documents internationally, your employment contracts and your independent contractor contracts that you might have for any given country, employment law is one area that probably changes more than any other area of law on an international basis. There's new employment laws coming out regularly in most countries, and so once a document has become 4 or 5 years old, there's a very high risk that it can be problematic. So make sure your documentation and practices are up to date is my second takeaway.